Hi, this is Subia from Law Info. General exception of IPC. Chapter 4 General exceptions. Section 76 Act done by the person bound or mistake of fact believing himself bound or by law. Section 77 Act of the judge when the act in judicially. Section 78 Act done pursuant to the judgment or order. Section 79 Act done by the person justifies or mistake of fact believing himself justifies by law. Section 80 Accident is doing a lawful act. Section 81 Act likely to cause harm but done without criminal intention and prevent other harm. Section 82 Act of the child and under the 7 years of age. Section 83 Act of the child above 7 and under 12 of the immature understanding. Section 84 Act of the person of unsound person. Section 85 Act of the person incapable of judgment by reason of intoxication caused against his will. Section 86 Offense requiring a particular intended to knowledge committed by one who is intoxicated. Section 87 Act not intended and not known to be likely to cause death or grievous hurt done by consent. Section 88 Act not intended to cause death done by the consent in good faith for the person benefit. Section 89 Act done in a good faith for benefit of child innocent person or by the consent of the guardian. Section 90 Consent unknown to be known given under fear or misconception. Section 91 Exclusion of acts which are offences independently for harm cause. Section 92 Act done in a good faith for benefit of a person without consent. Section 86 Offense requiring a particular intent or knowledge of commitment by one who is intoxicated. Section 87 Act not intended and not known to be likely to cause death or grievous hurt done by the consent. Section 88 Act not intended to cause death done by the consent in good faith for the person's benefit. Section 89 Act done in a good faith for the benefit of child and innocent person by consent of guardian. Section 90 Consent known to be given under fear or misconception. Section 91 Exclusion of acts which are offences independently of harm caused. Section 92 Act done in a good faith for the benefit of a person without consent. Section 93 Communication made in a good faith. Section 94 Act to which a person is compelled by threat. Section 95 Act causing slight harm. Section 96 Thing done in private defense. Section 97 Right of private defense of the body and the property. Section 98 Right of a private defense against the act of the person of unsound mind and etc. Section 99 Act against which there is no right of private defense. Section 100 When the right of the private defense of the body extend to cause death. Section 101 When such right extend to cause any harm other than the death. Section 102 Commencement and consequence of the right of the private defense of the body. Section 103 When the right of the private defense of property extend to causing death. Section 104 When such right to causing any harm other than the death. Section 105 Commencement and the continuance of the right of the private defense of the property. Section 106 Right of the private defense against the delay assault when there is a risk of a harm to the innocent person. Section 106 Right of the private defense against deadly cause when there is a risk of a harm or innocent person. There are exceptions. General exception under IPC. In another landmark judgment, the Supreme Court criminalized sex with a minor wife aged between 18 and 15 to 18 years. The court overturned an exception in rape law which allowed a husband to have sex with his wife aged 15 years and above regardless of the consent, including punishment. NGO Independent Throw filed a PIL in the court which prevailed the way for the ruling, and his rule will be applicable even in the case of the Muslim personal law. Criminal law deals with such type of cases in India, which are assorted in different sections depending upon their nature. The criminal law covers various punishments which vary from case to case, but it is not always necessary that the person gets punishment for the crime which he has done had been committed. The Indian Penal Code 1860 recognized defense in Chapter 4 under the general exception section 76 to 106 covered this the defense which are based on the presumption that the person is not liable for the crime committed. These defenses depend upon the circumstances prevailing that point of time, menseria of a person, reasonability of the action of that accused. Object of the chapter 1. Every offence is not absolute. They have certain exceptions. When IPC was drafted, it was assumed that there was no exception in the criminal cases, which were a major loophole. So, a separate chapter 4 was introduced by the makers of the code applicable to the entire concept. In short, the object of the Chapter 4 include exceptional circumstances in which an individual can escape liability, make him code construction of simpler by removing the repetition of criminal exception, burden of proof. Generally, prosecution has to prove its case beyond a reasonable doubt against the accused. Before the enforcement of the Indian Evidence Act 1882, the prosecution have to be proved that the case does not fall under any exception, but Section 105 of the Evidence Act shifted the burden on the claimant. But in the exception, as per the Section 105 of the Evidence Act, a claimant has to prove existence of the general exception in the crime. The fabrication of Chapter 4, Section 6 of the IPC throughout this code, every definition of offence, every penal provision and every illustration of every such definition or penal provision shall be understood subject to exception contained in the chapter titled General Exception. The general exception divided into two categories: excusable acts, judiciary justificable acts. Excusable acts, a mistake of fact under the section 76 and 79. An act of judge, an act performs in pursuance of an order under section 77 or 78. An excusable act is one in which though the person had caused harm, yet that person should be excused because he cannot be blamed for the act. For example, if a person of unsound mind commits a crime, he cannot be held responsible for that because he had not having menseria. Same goes to involuntary intoxication, insanity, infancy, or honest mistake of fact. A mistake of fact under section 76 and 79. Under section 76, act done by the person bound or by the mistake of fact believing himself to be bound of the law, including nothing is an offence which is done by the person who is or by the reason of mistake of fact, not by mistake of law, in good faith believes himself to be bound by law to do such act. It is derived from the legal maxim ignorantia facto dot exota, ignorantia juris non exit. Example: if a solitary firing on a bomb by the order of the officer in conformity to the command of the law, then he will be not liable. Under section 79, act done by the person justifies on mistake of law, believing himself justified by the law, including nothing is an offence which is done by any person who is justified by law or by reason of mistake of fact and not mistake of law, in good faith believes himself to justified by law in doing the particular act. For example, A thought Z to be murdered and in good faith and justified by law sees Z to present him before the authority. A has not committed any offence. Some case laws for section 79, Kiran Bedi versus Committee in Inquiry. Accident under 18 includes an accident committed while doing an lawful act, nothing is an offense which is done by the accident and misfortune without the criminal intention or knowledge. In the doing of lawful act in lawful manner by the lawful means with proper care and caution. Case law for section 80, King Emperor versus Timappa. Infancy, section 82 and 83. It includes an act of a child below 7 years of age. Nothing is an offense which is done by the child under the 7 years of age. Section 83, Case Law Krishna Bhagwan versus State of Bihar. Insanity. 84. An act of a person of unsound. Nothing is offense which is done by the person who at the time of performing it, by reason of the unsoundness of mind, incapable of knowing the nature of the act, that is, knowing doing what is either wrong or contrarily wrong. Case law of the section of 84. Ashiruddin Ahmad versus State. Intoxication. Section 85 to 86. The act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by the person who at the time of the doing it by the reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that that thing which intoxicated him was administered involuntarily without his will or knowledge. Case law of the 86, Babu Sadashiv Jadhav case. Case law for the section 87, 81, Bishambar versus Romal. Case law for the section of 87, Punai Fatima versus Emperor. Case law of the section 88, Dhanda versus Burelal. Case law for the section 90, Zakir Ali versus State of Assam. Private defense under section 96 to 106. There is some exceptions. Conclusion. So these are where the general exceptions which are available to the accused to escape liability or save himself from the offense committed. It may extend to even causing the death of the person or harm or innocent person to, depending upon the circumstances. The accused should also have the right to be heard, keeping in view the democratic character of our nation. That's why these exceptions are provided so as to present oneself in the court of law. Thank you.